Great. Our next case is 2019-659, 2019-900, State of Ohio versus Christopher Willingham. For the appellant, Mr. Van.
Good morning. Thank you, Chief Justice O'Connor, and may it please the court. My name is Daniel Van. I'm an assistant prosecuting attorney for Cuyahoga County, and I represent the state of Ohio in this case. And I would like to reserve 5 minutes for a rebuttal. This morning, I would like to focus my oral argument on the disputed proposition of law, as there is no disagreement among the parties that the Court of Appeals was without jurisdiction to sua sponte reconsider its own opinion once the state perfected its jurisdictional appeal to this court. Now, the decision of the 8th District is one of a handful of opinions in which the Court of Appeals overextended this court's decision in State versus Demetrius Jones. What is typically considered an insurmountable burden is now one that is easily ascertainable because courts are accepting an accused, self-serving, and uncorroborated claim of actual prejudice at face value to find a due process violation.
Mr. Van, can I interrupt you for a minute with regard to your first issue of the Court of Appeals reconsidering its opinion? Did it change the substance of the case on appeal to us?
No, Your Honor, it did not. I would say it did not significantly.
Did it change it at all? Is there any part of the propositions of law that are now changed based on the reconsidered opinion?
No, the proposition of law wasn't changed. The proposition of law I raised in the first jurisdictional appeal is the same as the second proposition of law. What did change was the addition of a sentence in paragraph 35 of the original opinion, which indicated what the second opinion indicated, the defendant still had a burden of establishing actual prejudice. But within that same paragraph, there was still a tone implicating that the state had some obligation to locate the defendant's claimed missing witnesses.
And that was in both opinions?
Yes, Your Honor. The remainder of that paragraph remained in both opinions. In the second opinion, that was paragraph 36 of that opinion. Okay. Now, as I indicated, the 8th District and claims of actual prejudice have really extended the holding of Jones, and particularly focusing on paragraph 28 of the Jones decision. Defendants are arguing, based on paragraph 28 of Jones, that their only burden is to identify potentially missing or unavailable evidence that would be relevant in bolstering their defense. As a consequence, pre-indictment delay is being found based upon speculation and possibilities. For instance, in this case, there were 2 separate victims. And with respect to DR, the 8th District found several things which cumulatively resulted in actual prejudice. And I think in this case, it's important to note that we do have it as part of the record, as part of the exhibits, DR's original police report. We understand what the allegations are. But when it comes to Mr. Willingham's side of the story, what we have are representations of counsel. There's nothing within this record to support that the hotel records, which Mr. Willingham claims would prove he had consensual sex with the victim, actually ever existed. There's nothing to indicate.
Wasn't there evidence at the hearing by an investigator from the defense that there were attempts made to find these records?
Yes, Your Honor. The defense investigator did testify that he had gone to the alleged hotel, which was now under different ownership. He received information that the former owner was apparently living in Cincinnati, but there is no indication whatsoever any additional attempts to secure that former owner's testimony, either at the pre-indictment delay hearing or later on during a potential trial. And what we really have is no indication of what hotel policies would have been. We have nothing to indicate what hotel surveillance would have shown, how long it would have been kept. In several instances, surveillance may only be kept for a matter of days. So when we're talking about this type of case, where there's a reportedly unknown assailant, subsequently identified through DNA evidence, it's entirely inconceivable how that evidence was lost as a consequence of the delay.
Well, let me ask you this, counsel. I mean, these claims of undue delay usually arise in cases where the prosecution begins long after the alleged incident took place and usually involve a known suspect as opposed to a stranger rape, correct? I mean, you rarely see undue delay in cases. You tested DNA, submit it to CODIS, it's a hit. There's rarely a claim of undue delay in cases like that, right?
I would disagree with that, Your Honor. I think as a result of the CODIS SAC-KIT initiative, what we've seen are both type of cases. We do have cases where there are known suspects. Sometimes maybe a known suspect really means is an acquaintance where the alleged victim knows her assailant by a street name, maybe some sort of name which actually isn't that person's legal name. We also have a number of unknown suspects. Currently in Cuyahoga County, we have over 100 John Doe DNA indictments where there still are unmatched DNA profiles.
Okay.
And so we do see in both type of cases pre-indictment delay claims being made.
What type of holding are you looking for from this court in terms of guidance on these types of claims? That's any different than we held in State v. Luck, as your opposing counsel stated, the proven unavailability of specific evidence or testimony that would attack the credibility or weight of the state's evidence against the defendant. Why doesn't that standard rise to the level where you believe that's applicable?
Your Honor, first of all, the state doesn't agree with the holding of Luck. That is paragraph 2 of Luck's syllabus. It's clear that pre-indictment delay can amount to a due process violation. What we are asking this court to hold, and rather it's a clarification of the decision in Demetrius Jones. What we're asking for is really that reaffirmance that pre-indictment delay be proven, first of all, through the fact that evidence has been proven to be unavailable. For instance, if I were to talk about one of the other claims relating to DR, specifically the efforts made to locate Mr. Tuck, as the transcripts of the hearing shows, really the effort to locate Mr. Tuck involved, going out to the home, I believe on 2 occasions, dropping off business cards. As any of us know who have handled litigation, prosecuted a case, and even probably defended a case, sometimes it does take multiple attempts to contact witnesses. Sometimes it takes subpoenas to get witnesses to testify at trial. Sometimes it...
Mr. Van Kent, let me interrupt you for a second. Does it matter that, at least with regard to the DR case, she says that the rape occurred after she left work and it took place behind some bushes, and the defendant is saying that no, it was consensual, we checked into a hotel. If the victim said that this took place in the hotel, and both accounts were that they were the same hotel, would the prejudice of pre-indictment delay be more, or at least the argument that there's pre-indictment delay and it's more prejudicial, be more salient here? But we have here, I guess, like Sake is saying, we don't really even know that whether this took place at a hotel or in the bushes, behind bushes.
Correct, Your Honor. In my opinion, in either event, it is troubling how these claims of pre-indictment delay are being determined. Now, counsel indicated that the state is looking for a specific role in sexual assault cases. But really what this comes down, it does stem from the 8th District's opinion in State versus Cafanteras. And I think the court is paying particular attention to the fact that these are consent cases. Now, to address that, the question, it's concerning because, as in this case, where the victim alleges it happened on her way to a vehicle, she was accosted by an unknown assailant. Pre-indictment delay is being found because defense counsel merely tells the court, well, this is my client's side of the story. There's nothing else to corroborate that. And what happens is that we are ending up having to dismiss cases and basically having to tell alleged victims of sexual assaults, the case had to be dismissed in this particular case. And, alleged victim is essentially told the defendant is claiming he paid you for sex. So even though this is your story, the court dismissed the case. And
wait a minute, counsel. I mean, is that really an accurate representation of what was presented here? I mean, you had talk about the hotel records, the fact that those records no longer exist. If there had been a video recording, that video recording no longer exists. So isn't that more than just somebody going in and saying, here's my side of the story, and I can't be indicted now? Or there was too much delay before the indictment.
Yes, Your Honor. There is much more to it than that. And that stems from what the defendant's account of the events are. And the frustrating thing is that there is absolutely no way to corroborate that claim. And we go back to the serious efforts, whether that was done in this case. The state does not believe that has been established. What we know from the record, page 33 of the transcript, is that the former owner now resides in Cincinnati. That's it. Other than that, we have no reason to believe that those surveillance tapes would have been kept but for the pre-indictment delay. And to go back to Justice Stewart's question about if we had a victim who indicated that this did happen in, let's say, a hotel room, the state still failed to see how those records would have established a consensual sex offense, because different things can happen prior to the act of sexual conduct. Consent can be revoked at any time. Two people can know each other, have a good time together, but not consent but one person doesn't necessarily consent to sexual conduct. So in the state's view, those types of records are not substantially probative such that the unavailability constitutes a due process violation. I do see that my time has elapsed. The state of Ohio is asking this court to reverse this decision of the 8th District and to remand this matter to the trial court. Thank you.
Thank you. Mr. Kuzmins? You'll have to unmute. There you go.
Thank you, Chief Justice O'Connor. Good morning, Your Honors. May it please the court. Paul Kuzmins on behalf of Chris Willingham in this matter. And I think what the prosecution, my colleague on the other side here ended with, when he says that when the victim says that she was dragged into bushes and sexually assaulted, and my client says she was taken to a hotel room for consensual sex, and he says that evidence that my client booked a hotel room that time during this time frame is not evidence of prejudice, shows exactly how unworkable the state's proposition here is. This is clearly relevant, probative evidence that since it's missing is prejudicial. And I want to start with the idea that and Luck and Jones have been properly decided. It's been the law since 1984 and earlier. They together have a clear and concise test that is workable. And what I did on this weekend, I think it's interesting because the state keeps referencing an epidemic of sorts, that there's so many defendants out there that are just making stuff up and they're walking away unprosecuted. And the numbers don't bear that out. Since 2016, when Jones was decided, it has been referenced 71 times. 5. If you add Willingham into it, 6. Only 6 times has a criminal defendant prevailed on the merits of a Jones-Luck test. Out of 71 citations, 2 other cases were remanded right in the wake of Jones for the trial court to apply the Jones test, and 2 other cases were remanded for ineffective assistance of counsel for failure to file a motion dismissed. Both of those cases resulted in criminal convictions that are now on appeal. So out of 71 citations, we had 5, 6 if you include Chris's case, where the Luck-Jones standard played in a way that was against the state's interests. But that 71 is so underrepresentative of what is going on. Cuyahoga County is ground zero for the sexual assault test kit initiative. It is the leading, I believe, county in the state of Ohio. And when you look for numbers online, according to the Plain Dealer report, the most recent one I could find from October of 2018, there have been 700 CODIS case indictments in Cuyahoga County. So this is just of these delayed prosecutions in sexual assault cases. This doesn't talk about delayed prosecutions in other contexts.
Well, Mr. Kuzma, let me just
yes,
stop you for a minute. But in this particular case, was there any evidence that there were records that even existed of this hotel, video records, surveillance footage, et cetera? Was there any evidence that it ever existed?
Yes. When Investigator Lucy went to the Red Roof Inn and had changed names, and he spoke with the clerk there, she confirmed that was in fact their policy in 2000 to take a driver's license when there's a cash payment for a room. So that is corroboration of that. Now, we attempted to go further and actually locate those business records in trying to find Mr. Patel in Cincinnati. We were unsuccessful in that, but we were able to get corroboration through the clerk who was working at the Red Roof Inn, who was able to confirm that their policy, and I believe the testimony is that it was policy even in 2000, that they did in fact seek get driver's licenses when making cash payments for room rents. So there is corroboration.
So assuming for the sake of argument that that's true, I think Mr. Van said, even if you have that he had a hotel room there, the victim's testimony was this: she was assaulted leaving her job, and this happened behind bushes or something. So how would that be relevant to his defense?
Well, it's in several ways. First of all, it cuts right against her claim that this happened in the parking lot, because he says he took her to the hotel room. And if we can show that in this same time frame that he was renting a hotel room at the Red Roof Inn.
But there's no way to tell whether he went to that hotel room by himself, is there?
Well, we don't know what the business records were reflected, but it's corroboration of what he said. It's corroboration of what his defense is, and it goes directly to her credibility. This is a he said, she said case, and her credibility, there's a window of time that's kind of unexplained here. She says she leaves the bar at closing time. She puts at 2:30, 3 o'clock. She presents herself at the ER, I believe, somewhere between 5:15 in the morning and 5:30 in the morning. That's consistent with, that gap in time is consistent with what our client, what Chris says happened. So there is corroboration in that way as well, that in fact he did go to the hotel room with the alleged victim in this case. And again, it was a cash rental, and I believe it was an hourly rate. All of that, it would have been confirmed by the receipt, presumably. He says they even photocopied his driver's license, which would have showed that it was him. That was there as well. So those absence of those records are critical, because they go to establish.
Well, and let's get to the second part, or second analysis of pre-indictment delay. There has to be analysis of why there was delay on the part of the state, and yes. Your client was unknown. Is that correct?
Yes, Your Honor.
So then, why doesn't the statute of why doesn't that take it out of the pre-indictment delay analysis? We presume that if a case is brought within the statute of limitations, that there is no pre-indictment delay unless we go through this analysis of the prejudice and the reasons for the delay on the part of the state. And most of our struggle has been with instances where the alleged assailant was known at the time, either through a report of the victim. Here, the assailant wasn't known. So why doesn't this simply fall into analysis of the statute of limitations on prosecuting the case?
There's a lot to unpack, Justice. There's a lot to unpack. No. So I'm going to start with this idea of statute of limitations versus due process. The statute of limitations is obviously plays a critical component. It's been expanded to be 25 years, and some exceptions of 30 years. But the due process is simply kind of an objective standard. It creates a point in time where there's an irrebuttable presumption that my client can't have a fair defense or fair trial, can't put on a fair defense, a meaningful defense. That's kind of an objective measure. Once charges are filed after that point in time, everybody agrees there's no way you can get a fair trial. It's an irrebuttable presumption. Due process is more nuanced. Due process provides it, and it necessarily requires that we inquire as to the facts of a particular case. Are the facts of this particular case such that the defendant cannot get a fair trial? When could the state have prosecuted him? How much earlier? Well, we've submitted and maintained all along in 2004. That is when, if this rape kit had been submitted in the course of its investigation, CODIS was started in 1995. It was well up and running in 2000. And if they would have submitted that database, that rape kit in 2000, the unknown DNA profile in there, at that point in time unknown, would have been in the database, would have been in the CODIS database. Once Chris's DNA was entered in that database, presumably in 2004, because that was his first felony conviction or arrest, he was also, again, there was a couple of years after that, 06 and 08, I believe as well, but in 04, the statute required that he be swabbed. Presumably they followed the statute, his DNA is in the profile. So 2004 would have been.
Is there any evidence that the records could have been obtained from the hotel back then?
Well, no, but there's definitely, we can all agree that there's definitely a better chance to find business records, 4 years after.
Better chance, but is there evidence that it could have been? I mean, that was a period of years that had passed too. What if they only kept records 30 days or 60 days?
Well, and we tried to get what the policies were from Mr. Patel in Cincinnati. We couldn't find him. Again, we could have also figured out who was working night shift. Perhaps we'd have scheduled to figure out who was working those evenings. There's other things we could do, but no, there's that. The point of the Jones test, though, also is when the indictment is returned. At what point that indictment is returned, and that was returned 17 years later. And when it was returned 17 years later, there's no question about it that those records have gone missing or are no longer available.
Mr. Kuzmins, I'm struggling a little bit with whether we should even have accepted this case. Once we resolve Proposition 1, which apparently there's no dispute between the parties about, now we're left with Proposition 2. Can you tell me, do we need to clarify Jones? Do we need to talk about whether actual prejudice is the standard or substantial prejudice? To help me understand that issue, do we need to clarify it?
I don't believe so. And I think the proof is in the pudding, right? We have, it is a high test. It's a particularized case by case test. We have over 700 indictments in Cuyahoga County out of the Sac case religion case. And that's in Cuyahoga County alone. We only have 71 cases that are citing Jones and even only 5 or 6 that show how rare it is that actual prejudice is found. And in fact, there are more cases in those 71 where the trial court granted a motion to dismiss and the courts of appeals reversed that granting. So this test is working. Nobody's complaining about it. The decisions that the state even points to are unanimous decisions. There isn't a judge that's clamoring for clarification saying Jones is unworkable. It has proven workable. Luck was proven workable when it started to get away. This court correctly in Jones raked it back in. I think it's important to show that the same arguments that the government is making today, the state is making today, are the same arguments that they made in Jones. When you listen to that oral argument, when you pull those briefs, when you see the arguments that they put forward in Jones, they're making the exact same ones today. The same cases are being cited, the same language of exculpatory evidence and concrete proof. These are the same arguments. They're unhappy with Luck. As Mr. Van had said, they don't agree with the syllabus in that case. They've been trying to rake back at it. This court has stayed firm, rightfully so. This test is working. And so, no, I don't believe that. I don't believe these are really factually dense cases to begin with. The trial court found that there was actual prejudice. The Court of Appeals did its own independent evaluation as well. And no, I don't believe that this is something that court needs to weigh in on. I don't see the confusion coming from the lower courts. And with that, if there aren't any other questions, we'd ask the court to affirm the Court of Appeals in this matter. Thank you.
Mr. Van, you've used your time. You may take a minute. You'll have to turn your mic on first, though.
Thank you, Yara. Sorry. In response to Appley's arguments, we do need a clarification of Luck, particularly when arguments are being made, such as in this case, if we look at pages 5 and 8 of their briefs to the trial court, referring to speculation as an old standard. We need clarification of Jones. We need clarification of Jones, especially where defense attorneys believe are putting themselves forward. If we look at page 8 of this transcript, and one of the claims was about club policies. What club policies could have been, it's not evidence within this record. We need clarification of Jones, particularly if we look at paragraph 30 of the Willingham decision, where the 8th District has found a pre-indictment delay based on possibilities. This court needs to reaffirm that pre-indictment delay is not proven through conjecture or speculation, and there needs to be a proven unavailability due to the pre-indictment delay period, not due to evidence that would have been lost anyway. Thank you again. If there are no further questions, I would ask the court to reverse the decision of the 8th District and to remand this matter to the trial court.
Thank you. Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision.